lile akusukuthi bona baye batshela amaphoyisa banika amaphoyisa ulwazi futhi abasolwa bona bathi baye baphoqwa ukuthi basayine lezi statement ngemva kokuthi bashawe noma bashayiwe bese bayaphoqwa ukuthi basayine istatement. Uma siqhubeka ke umsolwa wokuqala yena uthi uye washawa ngemva kokuthi aboshwe eLithabong eThembisa makaqeda wayisiwa eFosloras washawa nakhona ngase phambi kwenkantolo wayisiwa eDeepkloof esiphoyiseni. Mnumzane Ramusipilike yena uye washo ukuthi umsolwa wokuqala uthe uye washawa ngempama ngemva kokuthi wahlukunyezwa wafakwa futhi uplastiki ebusweni yena bambamba futhi nangezandla zakhe zisemuva ebanjwa amaphoyisa ebekade engakwazi nokuthi aphefumule. Lokho izinto ekuthi ziye zakhulunywa futhi nyakenye ngo-October abofakazi. Bese ke umnumzane uMngomezulu yena uma esho ngaloku khomba okwenziwa umsolwa wokuqala uthi yena kuyaphikwa ukuthi umsolwa wokuqala uye wayokhomba ngoba umsolwa wokuqala uthi yena akazange nje ayekhomba ndawo ayikho into aye wayikhomba. Uma siqhubeka nazi ezinye izinto ukuthi uye wazisho ubaba Baloyi ethi abukho ubufakazi obubonisayo ukuthi abasolwa bobabini bona baye balimala futhi naye uKennel Mbotho uye weza njengephoyisa elidala libele lisebenza esiphoyiseni lithe lona lelo phoyisa alizange libone impawu zokulimala kuye umsolwa uma eza umsolwa wokuqala kuyena futhi uthi akusilona iqiniso ukuthi umsolwa uye washawa ngoba kube umsolwa eshawe ngalendlela lebe kade echaze ngayo ngoba umsolwa kunalayi ukuthi uthi imoto iye yamiswa kwaphuma amanye amadoda angaba amahlanu ukuthi abanye abayisishagalombini bebakade basemotweni ithema baphuma bonke baye bamshaya. Manje uKennel Mbotho uthi uma engabe umsolwa wokuqala wayekade eshawe ngalendlela ayichaza ngayo ukuthi ushawe abantu abangaba amashumi nantathu 13 uma bemshaya bebonke labo bantu labo bekwamele ukuthi umsolwa uze kuye ehamba ngeambulance akusukuthi bekazozela ehambela njengoba ebekade esho uKennel Mbotho ukuthi umsolwa ungene eofisini emthola ehleli kulo lelo office futhi uthi umsolwa wekade bekazofika lapha yana eofisini ashawe ebonakala ukuthi ushayiwe yena uKennel Mbotho beyizothi uma ebona ukuthi umsolwa wokuqala ushawe ngaleyo ndlela bekazomisa konke lokhu ebekade ekwamele akwenze yena bekazocala athi umsolwa abonwe odokotela ngaphambi kokuthi angahle azokhuluma naye nakhona bengeke amvumele ukuthi agunyuluke ngemva kokuthi ambona ukuthi umsolwa ulimele ngaleyo ndlela. Uthi ke futhi kuyabonakala nakuyincwadi ezaseveleria esiphoyiseni ukuthi umsolwa wayekade engalimalanga uma kubhalwa phansi umsolwa bathe ufikile eValeria yena ungene eValeria engalimalanga azikho impawu ezibonisayo ukuthi wayekade elimele. NaseDeepkloof khona uma efika umsolwa kuthiwe ufike engalimalanga uKennel Mbotho noKennel Hadebe ekwamaphoyisa bekudala abalibele basebenza esiphoyiseni nabo bathi bahlangene naye umsolwa wokuqala bafika bathi akhumule phezulu bamthatha izithombe ngaphambi kokuthi agunyuluke ukubona ukuthi lo muntu lona akalimalanga na ngaphambi kokuthi angahle agunyuluke bese ngemva kokuthi sekagunyulukile nakhona baye bamthatha izithombe ukubonisa ukuthi nabo ngalesikhathi beze bekhuluma naye abazange bamshaye akabanga neempawu zokubonisa ukuthi ulimele. Manje umshushisi uthi ucela ukuthi lobufakazi bakho sibiya bokuthi wena uthi ushayiwe ucela ukuthi buchithwe ngoba azikho impawu nala kubhalwe khona akukho la kubhalwe ukuthi nangu ufike elimele ngaphandle kokuthi nje la ezandleni kwawukade kubonakala ukuthi ulinyazwe ozankosi mhlawumbe isizathu ukuthi bezikade ozankosi beqinile la ezandleni kuwena kodwa nakhona akusiyinto ukuthi bewukade ubonakala ulimele kakhulu bekuwukuthi nje bezikade ziqinisile ukuya ngomsolwa kwesibini ke manje ubufakazi oyikuthi buye umnumzane Mngomezulu uma ebuza abofakazi imibuzo yena uye wachaza ukuthi umsolwa ngaphambi kokuthi ayogunyuluka nge-19 zika June uye washawa eyikuthi amaphoyisa abekade bekhona bekade kuButhelezi uJonathan noMabhena ebekade nabo bekhona bemshaya umsolwa wesibini futhi bemchuba umsolwa wesibini njengoba bebalibele bamshaya umnumzane Mngomezulu uthi njengoba umsolwa wayekade eshawa kanjalo umsolwa wesibini yena ubekade ephambi baye bamthela ngamanzi la phambili emzimbeni ngaleso sikhathi bese ngaleso sikhathi umnumzane Mngomezulu wayekade ebuza umnumzane uMkhani imibuzo umnumzane uMkhani uye wala wathi cha lokho yena uyakuphika ukuthi umsolwa uye washawa futhi wathelwa nangamanzi uye wakuphika futhi kuthiwa kunalento eyasetshenziswa eyogesi eyasetshenziswa uMabhena noJonathan ukukushoka ngayo uyiphikile futhi umnumzane uMkhani uma embuza imibuzo umnumzane Mngomezulu futhi ke uthi umnumzane Mngomezulu uma ekhuluma uma ebuza imibuzo uye washo futhi nokuthi njengoba wawukade uthelwe ngamanzi enye into ebekade iyenza ukubonisa ukuthi wena wawukade uhlukunyezwa wena futhi awuzange ukwazi ukubona nokuthi kwenzakalani futhi awubonanga nokuthi ubekade abobani abekade bekushaya umnumzane uButhelezi yena uye wakuphika nakho lokho njengoba wayekade efakaza uye waphika wathi leyo akulona iqiniso ngoba akusinto eyenzakele njengoba kuthiwa wayekade ekhona ngaleso sikhathi uzebe ushawa uhlukunyezwa ngaleyo ndlela umnumzane Mngomezulu waphinda futhi wamtshela ngayo lento lebekade ushowukwa ngayo umnumzane Buthelezi uthe cha leyo nto leyo mina angiyazi angiyibonanga futhi umsolwa akazange eshowukwe ngikhona uma eqhubeka umnumzane Mngomezulu elibele buza umnumzane Buthelezi imibuzo uye wamtshela nokuthi amanye amaphoyisa uConstable uJonathan noConstable Mabhena bebakade nabo beyingxenye yalokushawa kwakho umsolwa wesibini umnumzane Buthelezi yena uye waphika wathi cha lelo akulona iqiniso futhi yena akakwazi lokho kwaqhutshekwa watshelwa futhi nokuthi ukuchubiwa umnumzane uMkhani wayekade ekhona no umnumzane uMkhani wayekade ekhona kodwa yena akayenzanga lutho kulokuchubiwa kwakho uthe cha ayi lokho akakwazi nakho ngoba lento ekhulunywayo akulona iqiniso ithema iqhubeka ke umnumzane Mngomezulu elibele ebuza imibuzo uye washo nokuthi wena ushayiwe futhi ubukade ugcine seyikuthi lokushawa kwakho ushawa ngendlela yokuthi uye wagcina seyikuthi uphuma uyopha ngamakhala nangomlomo ufakazi yena uye waphika wathi cha lokho akakwazi akazange akubone wopha futhi kuyokwaphikisana futhi ukuthi kungani ke ithema ufika kumantshi ungazange uchaze ukuthi wena uye wopha futhi njengoba bokade uthe wawufake iskipa esimhlophe ivest emhlophe kungani ungazange ubonise ukuthi naku ngichaphazeleke igazi lana ngicela ukuthi ningibonise ningise kwaDokotela noma ngicela ukuvula icala lokuthi ngishayiwe ngishawa amaphoyisa lokho akuzange kushiwo manje ke ummeli umjiyakho kuthiwa wayekade ekhona ngalesikhathi uyogonyuluka phambi komantshi uKronye kodwa awuzange uphike ukuthi lo muntu wayekade ekhona kubufakazi bakho kula uye waphika khona kodwa ngalesiya sikhathi akuzange kuphikiswe ukuthi umjiyakho wayekhona ngoba unomantshi uye wabhala ukuthi abantu bekade bekhona laphayana bekade kunomlisa obekade efake isudu. Uma kuqhutshekwa kuye kwashiwo futhi nokuthi wena kahle kahle ushawe kusukela nge-16 zika June, akusukuthi ukushawa kwakho kuqale nge-19 zika June. Manje ukuthi kuye kwabonakala ukuthi ingathi abameli kunala ukuthi bayaphikisana noma abakhulumi into eyodwa, ngoba omunye uthe ushawe nge-19, omunye wathi ushawe kusukela nge-16. Uma uqala ukuboshwa uye washawa umnumzana uMkhani ngempama, la ukuthi wena uye wathi ubukade ekushayela ukuthi ubukade ufuna ukuthi akhiphe naye incwadi ebonisayo noma into ebonisayo ukuthi ngempela uyiphoyisa ngalesikhathi nibe nikade nila uhlala khona ePhukeng. Futhi ke kuyabonakala ukuthi lo kuyagonyuluka wena uthe awukusayinanga, kodwa umantshi uye washo ukuthi umsolo wesibini yena usayine lo kuyagonyuluka ekhona naye umantshi, ukuthi leyo nto leyo iyabonisa ukuthi kuyaphikisanwa, akusi ubufakazi obuneqiniso, ngoba wena uthe awuyisayinanga, abameli nabo bathi awuyisayinanga, kodwa umantshi yena uthi uyisayinile ekhona. Wena la uthi uthe usayine, ubosayinela ukuthi wawukade ucela into zokugeza futhi wawukade ucela nokushayela ucingo abakini. Lokho into ukuthi kuyaphikwa, ngoba kuthiwa lesiya statement ngemva kokuthi sibhaliwe uye wasifundelwa, mawuqeda wasisayinda, kuthiwa wawukade wazi ukuthi bowusayinalani wena Ntanzi. Umantshi ke uye weza nalana enkantolo waphana ngobufakazi ukuthi umsolwa wesibini yena uye wazibonakalisa kuumuntu obekade ezilungele ukuthi angakhuluma, wayekade engathukanga, wayekade engasabiswanga, futhi ukhulume ngendlela njengomuntu obekade ezimisele ukukhuluma. Wasonga futhi umnumzane Baloyi ubufakazi bukaDokotela uHlokwe, la ukuthi uDokotela uye washo ukuthi wawukade ungumuntu wokuqala obekade yena emhlola, obekade ebuya ejele ezohlolwa, futhi uDokotela uye wabuza amaphoyisa ukuthi yini into ekahle kahle kwamele ayihlole. Bamtshela ukuthi kwamele ahlole ukuthi wena wawukade unalo igolide na ezinyweni, futhi yena ugcine seyikuthi uhlola konke njengoba wawukade ulethwe kuyena. Enye into ukuthi iyamangaza lana ekhulunywe uDokotela futhi iphinde yakhulunywa umantshi, njengoba wena uthe kumantshi awuzange ukhulume lutho, nakuDokotela uthe awukhulumanga lutho. Umantshi yena uye wachaza ukuthi thema ikubuza imibuzo ukuthi uyagula noma kunala ulimele khona, wena uye wathi cha awulimalanga ndawo noma awuzange umchazisele ukuthi ulimele. Wachaza futhi wena ukumantshi ukuthi uke waba nesifo senhliziyo, la ukuthi uke walimala emsebenzini njengoba wawukade usebenza emayini. Futhi noDokotela naye kwi-report yakhe uyabhala ukuthi wena uye wamtshela ukuthi cha awugula indawo, ayikho enye awulimalanga ndawo, into kuphela ukuthi ungathanda ukumchazisela yona ukuthi uke waba nesifo senhliziyo ngalesikhathi usase emayini. Manje umnumzane Baloyi uthi lokho kwenzakala kanjani ukuthi umantshi noDokotela abangakaze bahlangana bona babhale into eyedwa eshoyo ukuthi wena uthi unesifo, uke waba nesifo senhliziyo, kukhulunywa abantu ababini abekade bengakaze bahlangana. Futhi ke uma kubhekwa nasePrimrose kubhaliwe ukuthi wena uye wafika ungalimazwanga, uye wavalelwa laphayana ungalimalanga, nasePhukeng uma kufikwa khona kubhaliwe kuma-OB ukuthi wena ufike ulime ungalimalanga ndawo, kwabhalwa nakhona kuma-OB wakhona. Futhi wena msolo wesibini wena ithema uphana ngobufakazi, uye waphana ngobufakazi bokuthi wena wawukade ufake ivest ebekade inegazi ebelikade libonakala, kodwa uma ufika kuKennel Raphadu nge-19 zika June wena awuzange umbonise leyo leyo vest ebekade inegazi njengoba bengade sengishilo ukuthi uKenneth Rapad naye ushilo ukuthi awuzange umbonise ukuthi wena wawukade uchaphazelwe igazi njengoba ufika kuyena uthi leyo futhi awuzange umtshele nokuthi wena ungathanda ukuvula icala nokuthi wena ushawe amaphoyisa njengoba nomsolo wokuqala angazange afune ukuvula icala njengoba wayekade eshawe amaphoyisa. Manje uma siqhubeka ukuthiwa akuzange kube necala elavulelwa lamaphoyisa njengoba wayenikade enishaya nobabini eindaweni ezihlukile emalangeni ahlukile abazange lawo maphoyisa avulelwe icala. Nina nobabili nithi lezi statement zize sezibhaliwe baniphoqa ukuthi nisayine kodwa akukho la ukuthi nina niyasho ukuthi niphoqwe ukusayina istatement ezithini nina nithi anazi ukuthi kubhalweni kulezo statement. Futhi umbuzo ukuthi uyavela ukuthi kungani amaphoyisa bona beza ngezstatement ukuthi bazibhalele zona lezo statement akuzange kwaziwe ukuthi zibhalweni leyo nto leyo uthi umshushisi yinto engakhonakali akusiyinto engayenzeka esiphoyiseni njengoba nina nichaza njengoba uye wachaza msolo wesibini ukuthi uBrigadier Gininda uye wafika eza ngemoto iBMW embekade imhlophe wafika wahlala phezukwayo kulaye ukuthi uye wakunika istatement uthe yena ummeli umnumzana uMkhane hayi ummeli uye wathi leyo moto leyo imoto yenhlobo ka2021 ngo2020 ngaleli langa uBrigadier Gininda efika leyo moto leyo yayikade ingakasetshenziswa ekuchaza ukuthi umshushisi uthi inkantolo ibone ukuthi wena wawukade ulibele ukuguquka ubufakazi bakho akulona iqiniso. Manje ke uma singena kubufakazi beAVL uthi umshushisi ubufakazi beAVL bubonakalisa ukuthi yonke into emaphoyisa bebakade bayisho kubonakala kuyiqiniso ngoba umsolo wokuqala uthe yena kuye akuzange kwayiwa ePalm Ridge ukuthi kuye bekuyobonwa inyanga kodwa iAVL yona iyabonisa ukuthi kuyiwe ePalm Ridge kwayobonwa inyanga la ukuthi leya nyanga umkhulu ugcine naye seyukuthi uyafakwa estokisini eyohlonywa imibuzo bese bayamthatha bambuyisela emuva. Imoto iyabonisa ukuthi iye yafika ukuya ngalobufakazi beAVL yafika ePalm Ridge. Futhi ke nongumsolo wesibini njengoba kuphikiswa ubufakazi beAVL kuthiwa iyabonakalisa iAVL ukuthi nge-18 zika June 2020 imoto leyana iToyota Fortuner iye yafika eCarltonville esibanye Stillwater la ukuthi bekade kuyofunwa umsolo wesibini nalezinto ebekade ezikhulumile kuye kwayiwa nala ebekade esebenza khona njengoba kushiwo futhi nakuyilokhu njani nakulo kuyagunyuluka ukuthi imoto yona ihambe indlela ezinjani. Futhi ke nge-19 kulaye ukuthi umsolo wesibini uye wahamjiswa wayisiwa eMoroka esiphoyiseni la kuye kwayogunyuluka khona phambi kwaKenneth Rapad kwaqhubekwa futhi kwayiwa eFosloras kwabuyiwa kwaziwa eMoroka police station bese kwayiwa ePhukeng ngemva kwalokho kwabuyiwa kwaziwa ePrimrose. Lokho kuthathe amahora ukuthi bekade kuhanjwa ntathakusa kwafikela kusukele nge-18 zika June ukufikela nge-20 zika June iAVL yazibonisa zonke le indlela ukuthi zazikade zihanjwa umsolo wesibini ekhona laphayana emotweni. Futhi lobufakazi beAVL buhambelana nalento ebekade ibhalwe nakuyincwadi lezi ezibizwa ama-OB la ukuthi ubufakazi bona buthi imoto ihambe endleleni ethize naku-OB uma kuyafikwa kuyabhalwa ePhukeng kuyafika kuyabhalwa esiphoyiseni saseMoroka kuyafika kuyabhalwa eFosloras kuyafika kuyabhalwa nasePrimrose ukubonisa ukuthi njengoba iAVL ithi kuhanjwe kulezo indawo nabo amaphoyisa bafika kulezo indawo bayabhala ukuthi bafikile kulezo ndawo. Umsolo wesibini ke yena uthi uma efika kumantshi uKronje yena ngaphambi kokuthi uye ushawe ngemva kokuthi eseka gunyulukile kubonakalisi lokho ukuthi kungaba iqiniso ukuthi umuntu angashawa ngemva kokuthi sekagunyulukile bekade eshawelani ngoba bese seka yenzile into njengoba echaza umsolwa kubufakazi bakhe ukuthi amaphoyisa bayebathi ayenze leyo nto leyo. Manje isizathu sokuthi ashawe bese sekuyini ngoba umsolwa yena ushilo ukuthi umnumzana uMkhane ithema abalibele bemshaya uye wavimba amaphoyisa. Manje ukubonisa ukuthi umnumzana uMkhane njengoba evimba amaphoyisa, njengoba umnumzana uMkhane esho ethi ubekade emthengela nokudla, futhi kubonisa lokho ukuthi umnumzana uMkhane wayekade kuwumuntu olungile kuyena umsolwa wesibini. Manje asikho isizathu esingayenza ukuthi umnumzana uMkhane eze la enkantolo ethathe isifungo bese uphana ngobufakazi obungasilona iqiniso, ephana ngobufakazi buzofaka untanzi enkingeni ekuthini sonke lesikhathi lesi nangontanzi uyasho naye ukuthi umvikele emaphoyiseni bemshaya, futhi umnumzana uMkhane yena uthi umthengele ukudla, ukubonisa ukuthi wakade kuwumuntu olungile bengeke eze la enkantolo ezophana ngobufakazi obungasilona iqiniso. Manje ke uthi ummeli umshushisi yena uyacela ukuthi konke okubhalwe kulezi incwadi ezama occurrence book kwamukelwe, futhi nomnumzana uMngomezulu uye wavuma wathi lokho akusiyinto ephikiswayo. Kukhulunywe lokho nge-27 zika October nyakenye ukuthi akuphikiswa zonke izinto eziku-OB, ekuchaza ukuthi nalokhu kokuthi abasolwa bona bafakwe esitokisini bekade bengalimalanga akusiyizinto eziphikiswayo, njengoba kuthiwa lokho izinto ekuthi aziphikiswa, phecelezi they are not in dispute. Manje ke kuye kwashiwo ukuthi kubhaliwe nalapho kuyincwadi ukuthi lezo incwadi zingahle zithathwe zifakwe njengobufakazi, njengoba kunamaphepha amaningi asewasetshenzisiwe njengobufakazi. Futhi uye wafunda ke umthetho thizeni uma sekaqedelela umnumzana ubhaloyi, wafunda umthetho thizeni ukuthi konke okubhalwe kwincwadi zamaphoyisa i-occurrence book, ama-register lawa asetshenziswayo emaselini nama-pocket book asetshenziswa amaphoyisa, konke okubhalwa lapho umthetho wona uthi kwamele yonke into ebhalwe lapho iyamukelwe eyinkantolo njengobufakazi obuqinile, ubufakazi obuyiqiniso, ngoba akubonakala ukuthi amaphoyisa bangahle babhale izinto ekungasizona ezenzakele. Leso sinqumo leso sathathwa uJudge Mills ukuthi uye wakhuluma kwelinye icala elithizeni. Futhi into ebonakalayo kuleli cala ukuthi yonke into ebekade amaphoyisa bayibhala bekade kuyiqiniso, ngoba bebangenaso isizathu sokuthi bangahle bakhulume amanga ngezinto ekuthi ziyenzakele. Uma sibuyela futhi kummeli umjiyakho, ummeli umjiyakho wayekade ekhona laphayana la umsolwa wayekade egonyuluka khona phambi kwamantshi, futhi nasenkantolo ummeli umjiyakho wayekade ekhona, wafika futhi nasesiphoyiseni ngoMeyi ku-2020 la ukuthi uye ngoMeyi ku-2022 la ukuthi uye wayokhulumisana nomsolwa bekade umsolwa yena wafika watshela uBrigadier uGininda ukuthi nangu ummeli wami, etshelwa umsolwa wesibini. Kuye wafika naye uBrigadier Gininda washo ukuthi ummeli ufike ngaziswa mina umsolwa wesibini ukuthi ummeli wakhe njengoba ubekade emazi umsolwa wesibini, nale kumantshi kuthiwa wayekade ekhona ngalesikhathi ugonyuluka. Lo mmeli umjiyakho kube bekade kunento ebekade ingekho emthethweni eyenzakele lapha ehhovisi likamantshi, ukuthiwa ummeli bekwamele aphakame athi cha, Nkosi yenkantolo, lento ewuyibhalayo noma lento esanda kudolikelwa umsolwa ongimmele akulona iqiniso, leyo nto umsolwa akazange ayisho. Kuthiwa futhi ukubonisa ukuthi lezi zinto ebezikade yabhalwa laphayana bekade kuyiqiniso. Umsolo wesibili, umsolo wokuqala naye ithe ngemva kokuthi afundelwe yonke into ebekade ibhaliwe uye wathi cha ngicela ukuthi la nilungise ngoba niyenze impazamo. Bekazothi kulungiswe njani uma ingabe istatement esilethwe kuye kuthiwa sayinda lesi statement. Impazamo bekazoyibona kanjani uma ingabe bekangafundelwanga lesi statement. Manje uthi umshushisi kubonakala ukuthi umsolwa ufundelwe, umsolwa wokuqala ufundelwe lesi statement, futhi umsolwa wesibili naye kuthiwa lesi statement lesiyana wayekade esazi futhi ayikho into engahambanga ngendlela ukuya ngomthetho ngoba ummeli loyana umji yakho uye wakhipha naye incwadi ebekade eyinika umantshi ukubonisa ukuthi ungummeli yena ubekade emela umsolo wesibili. Futhi wabonakala nasenkantolo ePhukeng, wabonakala enkantolo nase-Boksburg, wabonakala futhi libele emele umsolwa wesibili. Kuthiwa ke uthi umnumzana uBhalwe uyacela ukuthi ubufakazi bale kuyagonyuluka obukade bulethwe enkantolo bubhalwe umantshi ukronye uthiwa kucelwa ukuthi buamukelwe njengobufakazi, futhi kubonakala ukuthi akuzange kube nento eye umnumzana umji yakho wayiphikisa njengoba kwakade kungenalutho obekade kusolisa khona lapho. Futhi uyacela ukuthi umnumzana uBhalwe uyacela ukuthi bonke lobufakazi lokugunyuluka kwamukelwe yinkantolo njengobufakazi bezinto ezenzakele, izinto eyikuthi abasolwa baye batshela amaphoyisa baphinda futhi batshela nomantshi izinto ebezikade ziyenzakala. Manje uyacela umnumzana uBhalwe ukuthi lokho kuthathwe njengobufakazi bezinto eyikuthi ziyenzakele, izinto eyikuthi ziye zabhalwa ngemva kokuthi zikhulunywe zitolikwe nangabo abasolwa. Ukuya ngomsolo wokuqala akuzange kube notoliki kumaphoyisa ngenxa yokuthi amaphoyisa nomsolo wokuqala bebakade bezwana ngolimi. Ummeli umantshi ukronye kuye kwaba notoliki ngenxa yokuthi umantshi ebekade ekhuluma isingesi, ingakho kuye kwaba notoliki obekade ezotolika lezinto ebezikade zikhulunywa umsolwa. Futhi ke umnumzana uBhalwe uma sekasukuma namhlanje uthi uyacela ukuthi ubufakazi bamukelwe, ubufakazi bamaphoyisa ngoba uKenneth Mbotho yena uye wachaza ukuthi uye waqeqeshwa ukuthi kube uKenneth futhi wabekwa eRandburg. Naye uKenneth Hadebe uye waphana ngobufakazi ebubonisayo ukuthi naye wayekade kuumuntu obekanegunya lokuthi angathatha ukugunyuluka noKenneth Rapadi naye babonakalisile ukuthi bangaba ngabantu abangathatha ukugonyuluka. Lokho ngamafuphi ikona into ebezikade zikhulunywa umnumzana uBhalwe kundamalanga amabili. Ngithe ngiyisonke ngingathathi imini yonke ngenxa yokuthi nabameli nabo kwamele basazokhuluma bakhulumisana nenkantolo ukuthi bona bathi bacela kwenzakaleni. Kukhona mhlawumbe oyikuthi anizwanga kahle mafethu nizwe. All accused understands, my lord.
Okay,
and I
thanks.
Summarize. Thank you, my lord.
Yes, Mr. Komezulu.
This, my lord. My lord, I'll request the court to bear with me because I'm going to make submissions orally.
I thought these were your hits.
Yes, my lord, I was going to supplement some.
Oh, yeah. You
Yes.
already do that. Fine, no problem.
That's correct. And further, my lord, it's an agreement between myself and Mr.
And?
Ramsepidi. It's an agreement between myself and Mr. Ramsepidi
Yeah.
that I'll make submissions for both accused number 1 and number 2 because I participated in the cross-examination of the state witnesses.
I'm going to allow it, but you know it's not allowed. You know that.
Court pleases, my lord.
Yeah, because you just told this court that your instructions were confirmed exclusively for Mr.
Sibia.
Sibia,
Correct, my lord.
and that his instructions were terminated. by SABC or legal aid, whatever.
That's correct.
Yeah, but look, I'm just pointing it out so that
Yes.
if it goes anywhere, they mustn't say I wasn't aware of it.
Court, please.
So if you have made that agreement, fine, you can go ahead.
Thank you for the indulgence. May I commence my argument by saying, my lord, accused number 1 was arrested on the 30th of May 2020 in Tembisa. He was arrested by Sergeant Mkhola, Constable Sadike and Constable Buteles at Vusumuzi section. My lord, this is not the arrest of accused number 1 that has been placed on record. During his testimony, he gave evidence that he was arrested on the 19th of March 2019 in Tembisa on the allegations of the death of Senzo Meyiwa. And he was taken to Chlorocop for interrogation, and he was then released after the officers that were in the office had a discussion, and he was not charged. On the 30th of May 2020, when he was arrested by Sergeant Mkhola, accused number 1 was arrested on the strength of a J50. And it is the evidence by Sergeant Mkhola that she was the investigating officer in the drug case, possession of drugs, under case number 2173 of 2019. When accused number 1 was approached in the execution of the warrant, he was then taken actually Constable Butelezi wanted to find his identity, to prove his identity by asking accused number 1 to produce his identification certificate or document. They went to his shack, so where they gain access to the shack. Accused number 1, at that time, during the arrest, he told the court that he was in company of other 2 gentlemen who were in a particular yard when they spotted a motor vehicle which was parked in the opposite side of the street from where they were standing, and they were approached by the officers, they were approached. Later they discovered that they were the police officers. They were ordered to lie down, and that's when he gave evidence that he was handcuffed from behind when he was on the ground, and he was lifted up with the handcuffs. That's how he was arrested. He was then, as they were going to the place where he resides, they wanted to find out, or they asked, Sergeant Mohola asked, as to who does he reside with in that address or the place where accused number 1 is residing. When accused number 1 was arrested, he was, according to his version or his evidence, sorry my lord, according to his evidence, he was taken to Litabong, a place next to a municipality area where he says he was assaulted and he was interrogated and asked about the death of Senzo Meyiwa. He was then brought back because the state laid evidence that he wanted to change the trouser on the basis that it was a brandhood, and Constable Buthelezi even mentioned that that trouser was dirty, and in contrast to what Sergeant Mohola said was that the trouser was expensive. That's why he wanted to change the trouser. The evidence of accused number 1 is that he messed himself up. That's the reason why he wanted to change the trouser. Accused number 1 testified that he was taken to Phosphorus, and that's when he met Brigadier Kininda. Before, my lord, he was taken, before the evidence of taking accused number 1 to Phosphorus, there's evidence by Sergeant Mohola that accused number 1 was taken to Vusimuzi Hostel after he was found with the unlicensed ammunition magazines to give information relating to a firearm. That's where they went to Vusimuzi Hostel. In Vusimuzi Hostel, they spoke to people that were of no assistance because they did not come to testify. What is of essence is that during the cross-examination of Sergeant Mohola, it has been canvassed by the defense that accused number 1, on the arrest that was effected on the 30th of May 2020, was unlawful and wrongful on the basis that the warrant of arrest, the J50, was challenged. The legitimacy of the J50 was challenged by the defense. Before this honorable court, which I will also argue later, my lord, is that there was no evidence presented by Sergeant Mohola, the affidavit to be precise, in support of the application for the granting of the J50 warrant of arrest. That is the submission that I'll also make at a later stage, my lord. The reason why we contend, the defense contends that the arrest was unlawful, it will prove that certain rights of accused number one were violated by depriving him of his liberty, which is protected by our South African constitutional law, Act 108 of 1996, precisely under Section 30. Sorry, may I just rephrase that one. My lord, furthermore, during the course of the evidence of Sergeant Mogola, Sergeant Mogola indicated that, or testified that she called Sergeant Monareng to beef up a security so that they can take accused number one to Basutwini Hostel. And she further made a call to Brigadier Kininda to say she had a discussion with accused number one, and it came to her attention as if accused number one is making admissions. Then it is her evidence that Brigadier Kininda instructed them to take accused number one to Vosloorus police station, where eventually accused number one met with Brigadier Kininda. I would like to point it out that when Brigadier Kininda interrogated accused number one at Vosloorus police station, there is no evidence before this court that he was in possession of a case docket 63610 of 2014. The evidence
Sorry,
by...
just for my understanding,
Yes.
you can't interrogate somebody or a suspect if you don't have the docket.
That's correct, my lord. That's how I understand
Okay,
law.
fine.
That's correct. The evidence that was given by Brigadier Kininda is that he had, or he was in possession of his diary, where he recorded things that occasioned on the 30th of May 2020 in Vosloorus. The emphasis on the docket and the requirements will later be argued, but what is of essence is that during the interview of accused number one by Brigadier Kininda, he was next to the police station. And the material that he could have used got that material from the police station in Vosloorus. This will relate to the warning statement, and this will also relate and be relevant in relation to the SAP 3MM. Then, after the interrogation, after Mr. Kininda or Brigadier Kininda confirmed that it appeared that accused number 1 wanted to make a confession, and he assessed his demeanor, he then made several calls to get an independent person to assist in the taking of a confession. And he managed to get Colonel Mboto, whom he requested to assist. And according to his evidence, Colonel Mboto requested that they should bring accused number 1 to Diepkloof police station. It's evidence before this honorable court that eventually accused number 1 was taken to Diepkloof police station by Colonel Mboto in order to take the alleged confession.
But is that correct, sir?
That's correct, ma'am.
When you say he was taken to Diepkloof police station by Colonel Mboto?
No, I say I rephrased that, my lord, with due respect.
Yeah.
I said sorry, but he was taken to Diepkloof police
Yeah, fine,
station.
fine. That's
Yes.
fine, okay.
Court, please. After the state led evidence that a confession was taken, then accused number 1 was booked in Villeria. That was now in the early hours of the 31st of May 2020, as per the records of the occurrence. The evidence of Mr. Mukhane or Sergeant Mukhane was that accused number 1 was then charged with possession of unlicensed ammunition and magazine under cast number 1/06/2020. This evidence, sorry my lord, accused number 1, after he was charged, then it appeared that there was an information to be followed up as per the confession or the contents of the confession, to make a follow-up on the traditional healer, and it's evidence that accused number 1 was told to sleep on this so that he will be taken to point out the traditional healer. When accused number 1 was booked out by Sergeant by Sergeant Mukhani, and the investigating officer, Sergeant Mukhola, of the docket 217-03-2019. He was then taken to Cambridge, where the state alleges that he pointed out the traditional healer. And my lord, it's evidence of the state that on the 1st of June 2020, accused number 1 appeared in Tembisa Court, Tembisa South. It was his first appearance. Then the matter was remanded to the 8th of June 2020. The state further led evidence that on the 5th, accused number 1 was booked in Albertine Police Station for the purpose of pointing out a particular place, and the state led evidence of Colonel Khateb, who assisted in the pointing out. My lord, then there was evidence that was led by the state that he was taken to Mahlabatini for the verification of the address, and in the evidence that the state has led, there was a version that was put by accused number 1 to the state witnesses. As the court has permitted me, as per my request, I will get into the arrest of accused number 2, my lord. Accused number 2, Bongani Sandi Sontanzi, was arrested on the 16th of June 2020 in Rustenburg. May I just confirm? Yes, in Rustenburg, my lord. He was arrested by Constable Mabena and Sergeant Mukhane at his place of residence. After he was arrested, he was taken to Pretoria Mort. When he was taken for Pretoria in...
Sorry, is it not something preceding that?
Yes, I'm getting there. I just
I
want
see,
to
okay.
draw the relevance
All
of
right,
that.
okay.
The reason why he was taken there is because they arrested him on the basis that he is involved in the case, in murder case of Kwanongoma under case number 163-10 of, sorry, 163, thank you. It's case number 163-10 of 2018, my lord. And the state led evidence that he was booked in Pretoria Ward, as it has been recorded on the occurrence book that it was a transit, which means he was kept with the purpose of being taken to the place where the offense was committed. He was detained. Then the following day, the 17th, there was an interview of accused number of accused number 2, my lord, in a boardroom where Sergeant Mabena, Sergeant Mohola, and Mr. Mukhane, Sergeant Mukhane, interviewed accused number 2 in relation to his whereabouts on the 26th of October 2014. Accused number 2 told them that if he was not, sorry, my lord, may I just focus on what the state said? Said he was at work, so that's why they had to make a follow-up. He was booked back, but informed that the following day he would be booked out to Carltonville, where accused was employed. On the 18th of June 2020, accused number 2 was booked out to verify the information that he has given to them at his workplace at Silver Mines, Sibanye, Stillwaters. There was evidence led by the state to the effect that they went to his employers and get certain information regarding his whereabouts, and it's evidence of the state that at a later stage, they were joined by Brigadier Kininda, who was in company of Sergeant Mhola. Sergeant Kininda at that time also interviewed accused number 2, and then Brigadier Kininda and Sergeant Mhola left. Accused number 1 with Sergeant Mokhane and Constable Mabena. Evidence by the state, my lord, further that Sergeant Mokhane, as he was conveying accused number 2, they then drove to Albertine for the purpose of investigating certain other cases. And when they went to Albertine, that's when he was asked confronted during cross-examination about the stoppage next to engine garage, as per the version of accused number 1 at that time. Then Sergeant Mukhane vehemently denied that they stopped near an engine garage, and there were witnesses that were called by the state who also denied being next to an engine garage during the conveyance of accused number 1 in a white Toyota Fortuner. In my the records will prove that Constable Jonathan denied having been next to the engine garage. Constable Buthelezi also denied, including Constable Maphumulo. The purpose, my lord, for taking the accused to driving with accused number 2 was canvassed by the defense as to why was he not booked in before you do your own investigations. An answer was given by Sergeant Mohola is that accused number 2 was bored. Mukhane, not Mohola. He was bored, so that's the reason why they had to travel with him. It's evidence that accused number 2 was booked back to Pretoria Mort in the early hours of the 19th of June 2020. It was 20 to 2 in the morning, as per the occurrence. Few minutes or few hours later, accused number 2 was booked out again. The reason for booking him out, according to the evidence of Sergeant Mukhane, was to take him to Foslores, because he was booked out under case number 163 of 10/2018. As they were proceeding to take accused number 2 to Foslores, they got a call that they must take accused number 2 to Moroka police station, and Sergeant Mukhane gave evidence that they drove to Moroka police station. And the evidence of the state is that Accused number 2 made a confession in front of or before Colonel Rappard, which has been denied by accused number 2. My lord, may we
What time is it now?
Yes,
What time is it?
11:15. May I just confirm? 11:17, my lord.
Okay, come back.
for the purpose of making a confession or the alleged confession before Mrs. Cronje. And it's evidenced by this court from the state that he was transported by Sergeant Mkhane and Sergeant Mabena, and they were escorted by the SWAT members to Boksburg Magistrate Court. The state further led evidence that the alleged confession was made freely and voluntarily, in sound and sober senses, without being unduly influenced, before a magistrate, Mrs. Vivian Cronje, who also confirmed that she participated in the taking of the confession in the services of an interpreter. Ms. Mutlaping was also used, and the state submitted evidence through Mrs. Cronje that accused number 2 signed the statement, and that has been confirmed by Ms. Mutlaping, who gave evidence that she's the one who gave accused number 2 a pen to sign. The state further alleges, after the taking of the alleged confession by the learned magistrate Cronje, to taking accused number 2 back to Pretoria Mort, where he was booked in. Then the evidence of the state further is about the first appearances of all the accused in Boksburg Court on the 27th of October 2020. Before their appearances, the state led evidence that on the 26th of October 2020, they formally charged the accused. On the 27th of November, the state further led evidence on the second appearance of all the accused before the magistrate in Boksburg, and the 5th of March 2021. My Lord, in summary, the defense is going to respectfully submit that from the evidence given by accused number 1, that he was assaulted, that he was tortured, that he was choked, it's the evidence that the court at the end of the day will make a ruling in terms of whether there was such an inducement. Accused number 1 says, yes, after I was assaulted, I had no choice. I had to protect my life because there was no one who could assist me. He had no option but to sign a statement. Then the defense will later then address legal issues in terms of the admissibility of such processes of proceedings of recording a confession. It's evidence also by accused number 1 that pointing out of the 5th of June 2020, it did not point out any place. he disputes that he directed the driver to a place where the alleged offense, or a particular place in Vosloorus. And he further disputes the averment of the state of Colonel Khadebe, who said, accused number 1 said, if you can take me to one of the entrances in Vosloorus, I'll be able to direct you or take you to that particular place. What is to be decided by this honorable court? Firstly, without wasting the court's time, we want to look at how accused number 1 was arrested on the strength of a J50. It is the submission by this defense that when an application was brought, there's no evidence before this court as to how was that application. As when that evidence is compared to the evidence of Brigadier Gininda, who told this honorable court that he brought an application in Boksburg Magistrate Court. In relation to evidence by Sergeant Mkhola, firstly, Sergeant Mkhola is not a commissioned officer. Section 43 deals with procedure to bring an application before a magistrate or justice for a warrant of arrest of a particular suspect. The persons entrusted or empowered, sorry my lord, to make such an application is the commissioned officer or the state prosecutor. The investigating officer, if he or she is not a commissioned officer, cannot bring an application before a magistrate. That proposition is, and the support of Section 43 is cited in Maposa versus the Minister of Police. My lord, I think the full citation is on my head. But there, in that case, we have, it's a civil suit against the Minister of Police, in that the plaintiff in that matter averred that he was unlawfully and wrongfully arrested on the strength of a J50. On the facts of that case, to support the principle is that Warrant Officer Comradi prepared an affidavit in support of the application, and the application was brought by a commissioned officer, Colonel Wenzel. So in my submission is that in the absence of this of evidence from the state side to suggest that a proper application was brought that warranted to deprive the liberty of accused number 1, is that that J50 upon which accused number 1 was arrested on its strength was illegitimate. Hence, the defense will move a submission that it was an irregular process to arrest accused number 1 on the 30th of May 2020. On the arrest of accused number 1 on the 19th of March 2019, he was arrested without a warrant of arrest. And the provisions of section 40, 1, I think subsection B, are applicable, subject to confirmation, my lord. But the importance and the significance of that evidence is that, firstly, the state did not contest that accused number 1 was arrested on the 19th of March 2019. To move forward in what actually transpired, the defense will submit and argue that Colonel Mboto, in terms of section 217, 1A of the Criminal Procedure Act, had no, this is what the defense will submit, that in terms of his rank, he is a commissioned officer. And this has been put to Brigadier Kininda when he testified as the head of the investigation, that there is a certificate which is issued for a person to be a justice of the peace. It's an A4 size certificate. And in terms of section 217, 1A, confession made before a non-judicial officer, that provision relates to a confession to be taken before a magistrate. And the question of law is, who is the justice of the peace in terms of that provision? It is apparently clear that the powers conferred to the appointment of the justice of the peace are provided or prescribed under section 334 of the Criminal Procedure Act, whereby it is stated that the National Commissioner is the one who appoints a justice of the peace on various districts. And it also, that provision, section 334, 1, and other relevant provisions, deals with specific matters to be taken to a justice of the peace. There is no amendment of section 217(1)(a) that is prescribed to include all the colonels as justices of the peace because of their ranks. That's my submission, that before this honorable court, it has not been proven by the state that Colonel Mboto produced that certificate and proved that he was the justice of the peace. Same applies to Colonel Rapatu. Colonel Rapatu, when I came on board, I canvassed this aspect with him during cross-examination. He took out an appointment certificate and said he was appointed by Ria Pierre, the National Commissioner. That's not what is required. That's the submission of the defense. Number two. Sorry, my lord. May I just have a seat? Number two, the defense would like the court to look at the date, the time accused number one was arrested. He was arrested, I think it was 12 minutes past, it's 12:30, according to the evidence of the state, but that is not in dispute. When he was arrested, on the same day, at night, the state alleges that he volunteered the information relating to the death of Senzo Meyiwa. And the state adamantly, and in terms of what Brigadier Kininda said, I was waiting for this time. There's something on my shoulders that I wanted to offload. This is the right time. The question is, if it was the right time in 2020, why it was not the right time in 2019 when he was arrested to offload that load? And the most important aspect that is important and which the defense will submit, that it was improper for the for Colonel Mboto to take a confession, even Colonel Rapatu, without the assistance of the interpreter. This is what Judge, I think it's Judge Brooke, in State versus Koki, this is what he maintained in paragraph 50, the relevance of an interpreter. That's why he mentioned that if the proformas and the statements attached thereto are made, the questionnaire is in English, and the answers given there are in English, then the competency of the Commission Officer Mboto in terms of English is at stake. It is also contended, it is also submitted, it is also held in that matter of State versus Koki about the involvement of a commissioned of a person who's taking a confession, and it is made in the same department by the police officer. That's why he mentioned in paragraph 53 that the legislature has seen it fit that magistrates should be used to take confessions. But this is the summary of what I've submitted in my written heads, my lord. So, my submission is that both confessions allegedly made by accused number 1 and number 2 must not be considered as confessions that the commission officers complied with the provisions of section 217.
Even Mrs. Kronje.
Now I'm getting to Mrs. Kronje, madam.
Let's see.
My lord, may I request Mr. Ramsipiti to read it for me?
What is the reason?
Is it
Hello?
paragraph 50, my lord?
Yeah, fine.
Yes.
If it may please the court, my lord, I'm reading from SABC Polki, the citation, I believe it's in Mr. Mgomezulu's arguments. At paragraph 50 thereof, the court remarked, all too frequently commissioned officers who record confessions do not use the services of an interpreter, that he or she and the suspect may both speak the same language, in this case is Xhosa, is not the only consideration. Questions on the pro forma are set out in English, so too are recorded answers as have been made by the suspect. The statement itself is recorded in English. What is never known is the competency in English of any particular commissioned officer. He or she is not a sworn interpreter. In court proceedings, they most often give evidence making use of the services of an interpreter. The reliability and accuracy of the statement is frequently called into question. It is frequently asserted that the statement was not recorded correctly and was not read back to the suspect, whether in English or in the language of its origin. Many of the routine concerns surrounding the accuracy of the record of proceedings pertaining to the obtaining of a confession and the level of compliance thereof required by the Constitution of those taking the statement could be overcome by having the additional input of a sworn interpreter during the process. Interpreters form an integral part of the magistrate's court proceedings. They are almost invariably used by magistrates when confession is recorded. The comments made in Ntantiso can be added to by the observation that the use of an interpreter would also be of great assistance in the attainment of the constitutional goal, a fair trial. Okay. And then we go to paragraph 53 thereof, my lord. It says, and I quote, the time may well have arrived for the legislature to give serious consideration to the amendment of the CPA to remove the possibility that a confession may be recorded by a commissioned officer of the same force which is charged with the investigation duties. This would go a long way to ensure that the quality of the investigative work shows improvement, which is necessary to ensure an improvement in the rate of successful prosecutions for serious crimes in this country. I have little doubt that the members of the South African Police Services were aware that at some point during the investigation, there may well be magistral scrutiny of their background leading to the recordal of a confession. There would be a resistance on the part of the investigation team to result to the improper use of police force or violence. That's why I quote, my lord.
Yes, thanks.
Thank you, my lord. That's the submission by the,
Yeah.
by the defense in relation to the admissibility of such confessions where an interpreter was not involved. There is that likelihood of misunderstanding. My lord, may I further address the court on on the evidence of the pointings out that the state has led evidence that Colonel Khadebe on the 5th of June 2020, accused number 1 pointed out freely and voluntarily. And in the same capacity as a commission officer, I submit that an interpreter was also not involved. The state must prove beyond reasonable doubt that a particular confession in terms of section 217 or a pointings out in terms of section 218 or an admission in terms of section 219 capital letter A must have been made freely and voluntarily in sound and sober senses without being influenced that way. It's my submission that the state has dismally failed to prove those elements, those requirements. In the state's failure to prove those elements dismally, the state did not satisfy this court that the rights of both accused in terms of section 35 of the Constitution were properly explained. And besides being the rights being explained to the suspects or to the accused person, accused 1 and 2, the question is, if accused number 1 was arrested on the 30th, if the law requires that he must be taken to court within 48 hours, and a confession was, as the state contended, it was already taken from accused number 1 on the 30th. Why was he still kept, or why was he delayed from being taken to court? As I submit that when one looking at the definition of a confession, it's an unequivocal admission of guilt. So, in the premise of law, there is a prima facie case established by such a confession. Why was he not taken to court? Instead, the state used a strategy to investigate the case of Senzo Meyiwa whilst keeping the accused in custody for other matters. If I'm not going to if I'm not quoting my colleague Advocate Baloyi, in his submissions, he also mentioned something similar to what is happening in Durban in that case of AKA. Is the same strategy that is used in this court, in this.
Which case is that now?
My lord, is the one that.
Can this court take cognizance of that?
But I'm glad if the court mentions that, but it has never been canvassed to the state.
No, I'm dealing with the law. I'm not dealing with any other thing.
Yes, my lord, but let's look at in.
No. That's gossip as far as I'm concerned. It's not law.
But
There's no judge who has found that this A, B, C, D. Please,
May I withdraw it?
let's
But my
speak
lord-
about law, not mlevo, gossip and what have you.
But that should have been conversed with the state as well, my lord, yesterday.
No,
May
you
I-
are
may I-
arguing. He was making a comment about Durban.
That's what I wanted to do. May I retract that with due respect, my lord?
Hello?
May I retract that and
Yeah,
proceed?
really.
Thank you, my lord.
Mr. Mieko, do you quote Mlevo as a court? Gossip. AK is arrested, he was driving, where?
You can't achieve this.
Thank you.
Thank
Yes.
you. Thank you, my lord. May I proceed?
Yes.
The rights of accused number 1 and number 2 were violated. As I've indicated in terms of the arrest was unlawful in respect of accused number 1. Number 2, there was no warrant of arrest when he was arrested for a murder case of Kwanongom. Up to now, the state has closed its case. Accused number 2 has never been taken to Kwanongom. It's my submission that he was unlawfully arrested and kept in custody. That violated his right to freedom. My lord, another important aspect that I wish to submit before this honorable court relates to the dates in which these accused were charged, formally charged. Accused number 1 requested to see his fingerprints in order to prove that he was charged on the 26th of August. But the date of the statement given to accused number 1 reflected the 23rd of August 2020. So up to now, the state has not proven a evidence rebutted or submitted by accused number 1 when he took a stand that he was not formally charged on the 26th of October. The same applies to accused number 2. He was not charged on the 26th of October 2020. It's my submission that the state, through the officers concerned, wanted to fall within the ambit of section 48 hours period to take them to court. My Lord, these are confessions. And this court this court has to determine the admissibility thereof. May I submit that there is a provision in terms of section 219 that deals with extracurricular statements. And that provision is confirmed in State versus Fortune Ngwenya. I'll give the full citations if so required. State versus Ngwenya, Fortune Ngwenya, State versus Magwaza, and State versus Muchili or Musili.
Muchinindi.
Muchili. Yes, ma'am. Thank you. Relating to the admissibility of an extracurricular statement made by one person implicating other suspects. The courts have found that those kinds of statements cannot be admissible against the other on the reasons of hearsay evidence, on the reason of the right to remain silent in respect of other suspects.
Yeah, the right case there is State versus Molimi,
Moli, thank you, my lord. That's the one that I was.
Constitutional Court.
State versus Moli. Thank you very much. It's my submission that, my lord,
Your colleague is laughing at me. Mr. Ngumalo.
that anything said by accused number one will only be relevant insofar as what he made on that confession. Same applies to accused number two. Anything that is said about accused number one in his statement, that cannot affect accused number one. Even accused number two, anything that is said against 3, 4, and 5 cannot stand against those accused. May I move forward, my lord, by saying, looking at evidence of the lead investigator as the state has led evidence of Brigadier Kininda. Brigadier Kininda, with the years of experience, I'll submit that certain important things he did not do during the investigations of this case. What is required from Maposa versus the Minister of Police in relation to the discretion that a commissioned officer must apply when he brings an application under Section 43 of Act 51 of 1977. My submission is that Brigadier Kininda misrepresented the facts to secure the issuing of the warrants of arrest of these accused persons. I'll submit with due respect that the mere fact that when he was confronted during cross-examination, he did not state the whereabouts of the accused. In that application, in that form, it appears that the address of the applicants were unknown. And in his affidavit that was read before this court, there's no way he averred that accused number 1 or number 2 was in this particular prison when he brought the application. One may then look on the legal aspect, on the context of a definition attached to an arrested person. If you deprive somebody of his liberty, in terms of Section 40 of the Criminal Procedure Act, by arresting him with or without a warrant, that's an arrest, my lord. And I've conversed with Brigadier Kininda that the procedure that he was supposed to follow, whether it's provided by the national instruction or otherwise, but the logic, the procedure was to requisition these persons that were in respective prisons into the court when the matter is placed on the roll. But I find no reason to hide the whereabouts of the suspects. Their names are appearing on the application and that prescribed form. What was a reasonable suspicion for him to bring this application? The application is brought on the 23rd of October 2020. Accused number 1, the state alleged that he made a confession on the 30th of May. 4 months down the line, Brigadier Kininda brings an application before a magistrate, misleading, misrepresenting facts. Accused number 2, arrested on the 16th of June 2020. Application is brought 23 October 2020. That warrant of arrest that was issued on the 23rd of October 2020 was unlawfully and wrongfully issued on the misrepresentation given by the commissioned officer, Brigadier Kininda. In Maposa's case, Judge Mahalelo was concerned about the independent opinion of the commissioned officer or the person who's bringing the application. I will make this submission based on the second affidavit read before this honorable court A227 statement by Brigadier Gininda. In A189 statement, or 187, he mentioned 5 suspects when he brought the application. In A227, he mentioned 6 accused persons. That's why I wish to draw the court's attention on the independent opinion of the commission officer. In 227, A227 affidavit, he mentions the 6th suspect, Kelly Kuman. Her involvement in the carrying out of a contractual killing or a hit. Now, that's how I draw the court's attention on what is required by Maposa's case in the independent opinion. I do not intend to call or to bring the evidence of the state in the main trial. But one knows, and it's before this honorable court, that accused are facing a murder case, attempted murder, robbery with aggravating circumstances, possession of unlicensed firearm and ammunition. The evidence led already for a period of more than 7 months has been extinguished or has been destroyed by one affidavit which was read for 10 minutes, if not less than 10 minutes. That's how he exercises independence, to make such an affidavit. What is he doing? What is his intention? As the head of the investigating unit, cold case unit, does he want to lead evidence to the effect that the court seized with this matter to decide on the admissibility of a confession? Will this confession relate to robbery, or will this confession relate to a hit? Because it is said under oath that it was not a robbery went wrong. It was a hit. But the court has not listened to any evidence of the state witnesses prior to this interlocutory application of evidence of hit. Instead, the court has the evidence of a robbery went wrong. So now this is now taken away by Brigadier Gininda in his affidavit. But the most crucial, important, and of significance is whether, if this court was to determine the admissibility of these confessions, will they relate according to the independent opinion of Brigadier Gininda on these two opinions? There's evidence by Warrant Officer Mako, who told this court that no, there was a difference of opinions amongst the people that were, or amongst the officers that were appointed by the National Commissioner and the Minister to investigate it. According to Warrant Officer Makubo, there were 4. It's Colonel Butelezi, Colonel Ramkhala, my lord, and the then Colonel Geninda at that time, and Warrant Officer Makubo. Officer Makubo at that time, or
Mr. Mgomezo, you want us to traverse the merits as you are doing?
no, my lord.
The law says I shouldn't allow you.
Thank you.
You want the case?
So, my lord,
I can quote it for you.
yes, ma'am. May I be clear, my lord, in terms of what the court is saying?
The merits. Warrant Officer Makubo came here and testified about the merits. He never testified about the trial within the trial. Never. Said, "Kade bakhuluma labantu labana, blah, 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 blah."
No, the
But me, I know nothing about how the confessions were taken. That's his evidence. But
That's
then
good.
he talks about going to Turkop, being directed, turning right, turning left, eventually getting there, etc., etc. Those are the merits.
My lord, may I just leave it and
Hello?
say, may I leave it by saying there's evidence that there were different opinions. That's what I wanted to say.
In the merits.
Sorry, my lord.
In the merits.
Through the investigations. My lord,
Yes, I agree with you. In the
Yes,
merits.
yes.
Not in the trial within the trial.
That's correct, my lord.
Yes, I
Thank
have a
you.
problem with that.
Thank you, my lord. May I move on by saying, my lord, sorry? Okay, no. Thanks. Thank you, my lord. My lord, the aspect of may I just have a quick recollection, my lord, of my, because everything is in my may I just quickly my lord, may I have 5 minutes? I just want to make certain.
Are you through with your hits?
No, I'm not. I'm not.
That's it.
I still have to canvass the issue of the OBs, the occurrence book, and the.
Yeah, you can do so now. Why don't you do it until the thoughts come back to you? Because now you are blank.
That's why I'm going to revisit. I'm taking everything in my mind, from my mind. May I request a few minutes?
What's the time, Mr. Baloy?
16 minutes to 1, my lord.
Okay, let's come back at 2.
Thank you.
Sorry. Where's Mr. Jonas? Jonas. Yeah. Yes, Mr. Ngomuzu.
Thank you, my lord. My lord, there are a few things that I want to make submissions on, which I have left out, especially, my lord, the evidence of Mrs. Vivian Cornier.
Mrs.?
Vivian Cornier.
Yeah.
The confession that the state said it was taken from in front or before Mrs. Cornier. My lord, a pro forma was submitted and a statement was attached to the pro forma.
Yes.
What has been canvassed to Mrs. Cornier on the statement is that the statement does not bear the signature of accused number 2.
But I recall he explained that the three of them signed the last page. That's how he says it was done.
That's correct, ma'am.
So he explained, unless you say that's unlawful, fine.
My lord, the concern by the defense on the signature was the signature that was appended on the pro forma, as opposed to a signature that does not appear at the last page of the statement that is attached to the pro forma. Hence, a comparison was drawn between a statement that has been taken.
Which statement are you talking about now? The statement you showed as an example.
That's correct.
How does it assist this court? How does it assist this court? Because that statement was signed by somebody who put his thumb and what have you. It has got nothing to do with Mrs.
My lord,
Cornier.
maybe the court did not hear why I'm talking about that statement. I'm not relying on the statement that has
You're
been
comparing
signed
it.
outside.
Wait, are you comparing it to the statement you brought?
My lord, may I just
Okay,
rephrase
fine.
it so that I understand myself?
Yeah, fine.
When Mrs. Cornier
Yeah.
was cross-examined, she was asked to compare
That's the point.
the statement of Colonel Rapadu and the statement that was attached in the pro forma that she conducted on
I
the
say
brief.
fine. So
Yes.
what about it?
I'm saying that statement at the back of it was not signed.
Okay, fine.
That's correct.
And any other submission? Yeah, you're saying one, it wasn't signed.
May
So
I
I'm
be-
saying any other submission?
May I be afforded to address things according to the according to the recollection of my memo?
Okay, fine, fine.
Yes. The magistrate, Mrs. Cornier, was asked about the meaning and the interpretation of paragraph 1A of the pro forma, which she read and starts with, I'm the magistrate.
Yeah,
I'm not involved. I'm not the police office. I'm not
involved in the
in the
investigation.
investigations.
Yes.
Yes. Then there was, in the reading of that paragraph, there was an element of promise, which Mrs. Cornier, when she gave an answer, she told this court that that might be construed as a promise.
Yes.
And furthermore, what Mrs. Cornier has realized on the evidence when accused number 1 was brought before her, that he did not take a bath. And accused number 2 further told the court that I told the interpreter that I did not take a bath. I want to call my family. I didn't call, and I want to change the clothes. I'll submit or I'll argue later, my lord, before my conclusion of my argument, that was an element of torture. It's against human dignity.
So Mrs. Cronje tortured your
No,
client.
no, my lord, I don't want to make assumptions.
But you are
saying,
submitting
my
that. You
lord-
say it's an element of torture.
Yes, I didn't say Mrs. Cronje tortured accused number 2.
Who was he dealing with? Was he not dealing with accused number 2 or 1, whatever?
Was dealing with accused number 2,
Right.
and accused number 2 said he did not take a
Right.
bath.
And
Mrs.
you
Cronje.
are submitting that it's an element of torture.
That's my submission as a
against who?
defense.
Against who?
Sorry?
Against who?
The state.
The state.
Against accused number 2.
That's the point.
Against number
That's
2.
how I understand it.
Yes. But that's my submission from the defense.
Yes.
When looking at the definition of what is torture.
Fine. Okay.
The evidence of Mrs. Cronje in relation to what she has discovered after she took the alleged confession from accused number 2. She considered that accused number 2 was not brought to court within 48 hours.
She didn't say that, Mr.
We can go on record.
No. I listen. Let me tell you what she said. She says she was told that by your client that she wasn't taken to court within 48 hours. But she only had one aspect of that evidence. She didn't have a counter argument about that evidence. That's
I
what
don't-
she said.
No, I beg leave to differ with the court. That's not what the magistrate said. The magistrate said accused number 1 said he wanted to go to court.
Right?
He
Yes.
yes. But now, when she was cross-examined, it was put to her that when she was brought before her, 48 hours has lapsed. And she even said, I have discussed that with Mrs. I have seen that irregularity. And I have discussed that irregularity with Mrs. Du Plessis. Then I asked her, what, as you have promised that for any irregularities that will transpire, you are going to remedy the situation. What did you do? Nothing.
Okay, you can. I'll check it, but I don't recall
Yes,
that.
please, my lord.
I can't recall it being
Yes.
that way because she said I only had one version before me. Mr. Baloi, am I correct or am I dreaming also?
I'm just quickly checking the record. I think
You have it there.
it's one aspect that we need to verify. My recollection was that she said that was not the issue before her, something to that effect. But
Okay, we'll check it. Fine. You can continue, Mr. Mzome Zulu. I'll check it.
Thank you, madam.
Okay. Yeah.
There's evidence by Mrs. Cronje about the appearances of those officers, that they pose a threat. They're heavily armed.
Yes. And they were doing their job. That's what they said.
Yes,
Fine.
they were doing their
And then she construes it as posing a threat. Fine. I agree.
But now, the court must assist or will assist the parties to determine on the admissibility of those
Yes, of
confessions.
course. Of course.
But now, a threat in terms of the definition of making a statement in your sound and sober senses, I'll refer the court to the definitions as They are written on my heads of argument. It also involves a form of the presence of the police. There's authority to that effect. Having fully armed, and the person who was going to take the confession, a magistrate, felt threatened. How about the person who was under arrest? That should also be considered.
Fine.
Yes. And my lord, before I get into Mjiako, I just want to get into that 2171 Roman figure 2, the one that prescribes the magistrate to take a confession. On its own, it vitiates all non-compliance with that and the irregularities that emanated during the course and the proceedings of recording such a confession. Vitiates all the elements and the prerequisites of section 217.
Okay. So she didn't comply with 217. Fine.
Thank you, my lord.
Good.
My lord, the court was told that there was somebody in the office, room 2, who came to act on behalf of accused number 2. And there's evidence before this court that the FFC number was recorded to prove that he was an attorney. That's not irrelevant. That's not irrelevant in terms of legal representation. The court must also consider the fact that Mjiako played a very passive role if it was Mjiako. Very passive role. My lord, is there any evidence that has been presented before this honorable court by the state through the evidence of Mrs. Cronje that Mjiako was ever communicating with the presiding officer who was taking a confession? There's no such evidence.
But look, it's a question of style. I know a judge called K. Lewis. K. Lewis would sit for 3 weeks listening to evidence and not writing anything. Just doing this. Come, you argue. After 3 weeks, you come, you make submissions. And then he adjourns for 6 hours, so 2 hours or 3 hours, he delivers a judgment. Just like that.
Yeah, but
Have you heard about that gentleman?
it's an individual style.
In fact, my lord,
Hello?
during lunchtime, Mr. Newman was relating a similar story about a judge in Maritzburg who does the same.
Yeah, so it's a question of style. So, K. Lewis, they say he was a genius. Fine, maybe Mjiako is a genius also.
That's an
But
assumption.
I'm not saying you mustn't make that submission.
But my lord, yes, things were guided by the ethics.
Yes, fine.
Yes, that judge, I don't know how he operated, but Mjiako was guided by the ethics.
Okay.
Yes, because in terms of representing a client, we act in the best interest of a
Yes,
client.
you're right.
When Mjiako was in a passive role, who was he acting on behalf of? Who sent Mjiako there? No, let alone whether he was instructed by the family. We are concerned about the involvement of Mjiako in court. There's nothing that was said by Mjiako from when he entered that room 2 up to when he left. He never participated. Once you tender a guilty plea, I'm making an example. as an attorney or an advocate presenting a guilty plea, all the elements that are there are presented by you to the presiding officer.
Okay, I've heard you, but
Yes.
you must recall that, and I'm not saying it. Kronji says she asked Mjiako, I think she says that, if they had consulted. You remember that piece of evidence?
I can't recall the time.
Okay.
That was,
Okay,
you can-
she said, anyway, she said she thought they had consulted.
she thought.
Yeah,
that was
because accused number 1 said, or 2, whatever, he said, this is my attorney. I want to continue with him. That's what she says. I don't know. I still have to consider that evidence, okay?
Thank you, my lord. But I wanted to draw the court's attention on the role played by Mjiako, not about what the presiding officer said. It's what Mjiako.
But you see, now you're criticizing an attorney. And I'm saying to you, it's a question of style.
Yes.
Like me, I've got my own style. There's another judge who will come here and just sit like this for 6 months. And after 6 months, write a judgment. And you have never seen those judges somewhere here. Doesn't ask any questions. You argue, you keep saying. Me, I ask questions, I want to understand. Maybe that guy is a genius. He listens to the evidence, he makes conclusions, he looks at Mr. Ramusipili's demeanor, he makes a conclusion, etc., etc. But now you see, they are saying because Mjiako didn't do A, B, C, D, E. The question is, was Mjiako an attorney or not? Every day in these courts, clients fire advocates, clients fire attorneys because they're saying they're incompetent or they're not representing me well. It happens. But the question here is, or was Mjiako an attorney, admitted attorney, qualified to practice?
I'm making a different submission in
Okay.
relation to Mjiako, because we did not challenge the credentials and his qualifications.
You did not, of course.
I did not. But
And
I
you know
put
what?
it-
You also didn't call him as a witness. You could have subpoenaed him, and you could have, like I say, if you say you had the best interests of your clients and he was not instructed by your client, you could have preferred charges of fraud against him. You could have preferred charges of professional misconduct against him.
But-
Diego was left alone.
My lord, I cannot deviate from the principle
Yeah,
that the burden is not upon
of course, yes,
it's
of
not
course.
upon the accused.
Yeah.
It's still with the state.
Yes, you're right.
If the state, the defense has never submitted any kind of document
That's it.
to
Yeah.
prove the existence of Mjiako, to us is a fictitious somebody.
Yes, quite,
Yes.
no problem.
The state must have brought Mjiako and say, hey,
Oh,
he's lying, this man.
okay.
He paid me so much. I'm the one who did this. He said this and that. Why is Mjiako today?
No, fine. You can make
Thank you, madam.
we can make other submissions concerning that. No
Yes.
problem.
My lord, the letters coming from the office of Mjiako Attorneys Incorporated. If I come on record, I place myself on record, either in a civil matter through a notice of appointment as attorneys of record. Even if I withdraw, I file a notice of withdrawal as attorneys of record. But Mjiako is writing a letter to the DPP. That letter is not even directed to the court. It's directed to the DPP to say, convey this message for me. That's unethical.
Miss Nchio, did you hear about it?
Yes.
She came to court and withdrew on behalf of Mjiako, according to the evidence.
I think I have to confirm that, because
Now I'm telling
The
you, I was
letter, my
listening.
lord.
Nchio came personally, she's a female, and your client said, even her, I fired her, chased her away. But on record, it's, you can ask your advocate, your colleague there. It is on record that Nchio came to court and withdrew on behalf of Njiako. That's the evidence before
My
me.
Lord, the evidence, insofar as my recollection, and I'll verify that evidence, is the evidence of a lady that appeared in Tabane for accused number 2 to withdraw. as
Okay,
item
fine.
of record.
You remember it like that. Mr. Rampesele, how do you remember it?
My Lord, the recollection is that the withdrawal by Ms. Nchia
Nchia,
was
yeah.
in the Tabane Magistrates
Ye-
Court.
Yes.
However,
On behalf of whom?
on behalf of accused number 2.
Are you listening to yourself?
The Tabane matter.
No,
my
no, are you
Lord,
listening to
concern-
yourself? You're saying Nchio,
Nchia,
Nchia,
yes.
recused herself.
She withdrew,
She withdrew.
from the matter
On-
on
yeah.
behalf of Mr.
You see, you said on behalf of accused number 2. That's what you said.
That's the slip of the tongue.
Oh, I
behalf
see.
on behalf of Mr. Mjiako.
Okay, fine.
Yes.
All right, fine. Yes, Mr. Gomezulu.
In connection with the legal representation, I'll just conclude by saying all that was done in taking confessions or a confession in the presence of a magistrate was not done where it is required by the law or by the Constitution that the rights were explained properly to the legal representation.
So the rights were not explained.
That's my
Nothing
submission.
was explained according to your client. Nothing. And then, according to your client, he only had one bit of conversation with the magistrate through the interpreter to say, can you tell that lady that I haven't had a bath since the 16th and I want to go and see my child or phone my child and I want to see my parents or my sister or my girlfriend. And that was the end. That's the evidence of your client. And after that he says, "Ngabheka phansi," I looked down. Never participated in those proceedings. That's the evidence we have.
My Lord, I believe and I submit with due respect that I cannot argue that point in isolation.
Okay, of course.
Yes, because there are certain things that were not complied with by the
Yes,
state.
yes, I agree.
And to single out and to be selective on could be unreasonable for accused to have performed in a particular fashion cannot be challenged on the basis that if it was his style, no one can challenge him for that. But what is very important here is whether the state
Has proven.
satisfied the court that he made a statement freely and
Yes, of course,
voluntarily
yes. The
in
onus,
sound and sober
the
sense.
onus is always on the state.
Yes.
Always. It never shifts.
And in State versus Yolelo, if I'm not mistaken in terms of the citation, and State versus Zoma, it also emphasizes the burden of proof.
Yeah.
Whether the accused or is lying, is misrepresenting his facts, distorting information, but ultimately the law requires the accused person to give an evidence which is both reasonably and possibly true.
Yes, that's all.
Hence, I'm saying in my submission, the evidence given by Ntanzi, to some extent, I'll discourage the fact that certain issues must be excluded as being reasonably and possibly true. I'm referring the court to the evidence of the AVL. Ntanzi informed his lawyers that this is what you must tell the witnesses.
No, fine.
When he gave evidence, recollection of the mind, the vividness of the recollection cannot be negatively attached to accused number 2 under the condition and the circumstances that he was in. He was under arrest. Firstly, Ntanzi does not reside in Katlehong, does not reside in Albertine, but he managed to secure the name that he may use at a later stage for the recollection that I was at this stage, at this time, in this place. Firstly, that what he told the court, I saw an engine garage where I saw a board, Albertine. You bring the AVL. It confirms that on the 18th, a Toyota Fortuner was at Collins, between Collins and Mali, next to an engine garage. That is consistent with his version. That cannot be excluded. And number two, my lord, Ntanzi is telling this court about the dumping area. Whether the vehicle was located next to a dumping area, he is subject at that stage, under those conditions, he was capable of making a mistake. But there's one aspect that Mr. Dupree confirmed, is that a Toyota Fortuner was located driving, off-ramping from N3, joining Heidelberg Road. That was even said by Ntanzi before Dupree was called. He talked about Heidelberg Road. That's the version that we put to Mr. Mkhane. He was driving at Heidelberg Road. Talk about Market Street, New Market. I asked Mr. Dupree, can you please, the actual image, can you assist us if there is no dumping area in that Heidelberg Road? He saw, he mentioned, I can't quote it verbatim, but that's why he confirmed that he can see the municipality dumping site or something like that. Consistent with what Ntanzi was saying. And what I wish the court to consider mostly, all the evidence presented by the state is presented in the form of writing, meaning they were recording all what was happening on those days. Is that expected of Ntanzi, who had no pen and paper, to make a vivid recollection of what happened? The answer is in the negative. But what was good and brilliant about Ntanzi is to spot a particular place, where I'm going, where are they taking me to? But if I can see a word or something, I'll make sure that I'm going to use that. This is what Ntanzi has done. This is what we are busy dealing with right now. He talked about engine garage, he talked about Albertine. What is of very much importance when they collected Rapado in Cross. If Rapado, the court can decline or reject the evidence of Mr. Ntanzi to say, no. There's nothing like Chris Hani Baragwanath State Hospital. The AVL confirms that the vehicle on that particular day was driving at Chris Hani Road. At, if I can remember very well, it was 1558 when Dupree said they lost the connection, if I may put it that way. 1558, and it was regained in 1603. That is its evidence. In between, where was this vehicle? And when he put the actual image of Baragwanath after the court has canvassed the issue of a breach, it has been put by that witness during my cross-examination to say that breach is after the gates of Baragwanath. It's after the gates. It cannot be said that the location was caused because that vehicle was under that bridge. If it was under that bridge from 1558 to 1603, what was it doing at that time? So the evidence or the version of Ntanzi should be accepted to be both reasonably and possibly true, because this thing comes from somebody who did not record anything from the 16th up to the 24th. He may be doubted about the evidence of Orlando, he doesn't know, but what was of importance to him to see that name Orlando. And one may assume that he was at Orlando because he assumed that he was at Albertine. I may not attach the blameworthy to accused number 2. Whether Kininda or Brigadier Kininda arrived with Sergeant Mhola in a white BMW, they may state, as these witnesses have denied, that this is the version of accused number 2 Ntanzi. Say no. That's where I was made to sign. And my Lord, before I forget, there was something that also makes me to believe the evidence of Bongani Ntanzi. He talked about water that was used. And Mkhani confirmed that they bought water. Why? Is that a coincidence? The answer is no. It's consistent with what occurred on that particular day. Water. My Lord, on the evidence of the AVL, I was really disappointed by the evidence of Brigadier Kininda. I can repeat it. I was really disappointed by the evidence of Brigadier Kininda. You cannot cure the damage that has been already there. In relation to the date of the 24th of June 2020, it is clear from the evidence of Jonathan and Lisereng. They went to Pretoria to fetch Ntanzi, who was transported on a white Toyota Fortune. These people were at all material time escorting. They never lost sight of the vehicle up to Boksburg. Gave that evidence. Kininda comes and say, no, accused might have confused a buggy with a canopy. This is really disappointing. And this has been confirmed that he has been transported. I even referred to Priest that what you are relying on that AVL is not consistent with that date that you mentioned, that vehicle was in Benoni. Because this is what Jonathan has said. So the evidence of Ntanzi should be accepted as both reasonably and possibly true. Even accused number 1, he gave a very consistent evidence. The evidence of the doctor or the dentist, the primary object of taking Ntanzi there was to confirm if Ntanzi had a gold tooth. So nothing more, nothing less. But that doctor confirmed that Ntanzi did not have a gold tooth. And during the interview on the 17th of June in Pretoria at the boardroom, they confirmed the state, Bomkhane, Mohola, whoever was there, that Ntanzi had no tattoos. Sorry, my lord, I just want to check.
I'm sorry, my lord, I was just trying to my learned friend that I found the portion that the court was
The what?
looking. I found the portion that the court was looking for regarding the evidence of Ms. Grenier
Yeah.
and the 24 hours, and I was inquiring from him as when can we put this on record.
Yeah, you can put it on record. He can put it. If he agrees that that is the evidence I was referring to.
We requested also to revisit the records, my lord.
Your colleague here, he says he has located that area of the record. Are you saying that, Mr. Baloi?
Indeed, my lord.
Okay, just tell me what is it so that when I check it, I
Can
should
I
know.
bring it on Monday? All what I can.
What is the page?
My lord, it's
Page?
the report of the 20th of October,
20th October?
and it's on page 66.
Page 66.
Yes.
Lines?
And it's from line 10,
Line 10.
and it carries on until page 67.
Yes.
And the exact part that the court was referring to is on line 10,
Line 10.
line 10 to 14 on page 68.
What does the court say there? Yes.
Well, it says, Ms. Grenier says, advocate, I can only take or go based on your client's words or what your client told me that he was arrested on the 16th of June. I cannot tell as to whether he was arrested on the date on this particular matter or on another matter. I cannot say when and when he did not appear or on which matter.
Okay, fine. But I'll check it. Fine, no problem. Yes, Mr. Gomezul?
Thank you, my lord. Sorry, my lord, may I just consult you? May I quickly approach office number 1, my lord? My Lord, before I rest on
Yes.
my submissions, I just want to make few things after consulting with accused 1 and 2. Firstly, injuries sustained by accused number 1 at the time he was taken to Mboto. It is evidence before this court that the wrists were swollen as a result of the handcuffs. Secondly, what he also informed me is the manner in which he was arrested, and it's evidenced by Constable that when he approached them, they had to apply a tactical takedown. So,
Right.
I wished the court to consider or to take it as a factor in relation to elements of inducing threat.
No. The court is
persuade.
this court is going to take everything into consideration.
Yes.
Mr. Rapi, just look at the notes I've made here, so that, yeah, can we take this? This is evidence of accused number 1 and 2. Just go through this and tell me. I read everything. Just go through it. Just casually. Bheka lapho Mr. Miyeke. No, Mr. Ngumalo. That's the evidence and the cross-examination of accused number 1 and 2. It's about 5,000 pages. I've read every page there. Hello? Am I telling you the truth? Huh?
After Mr. Madot, I've seen the highlights, the notes on the
Thank you.
pages.
Yeah, you can bring it back. I'm not the type of judge who... And I say everything I've read. It's about 30,000 pages, that evidence we've been doing. I've read everything. Okay, so are you through, Mr.
The last aspect, my Lord, what is canvassed by Ntanzi, but most of the things will be also supplemented by my colleague, Mr. Ramsipin. The last part of my submission is that he indicated that about the evidence of a movement, which the court was also was concerned at the garage, at the engine garage, the movement of people.
Okay.
I wish the court to consider as well the fact that it was a COVID and movement was restricted
Yes.
to the extent that the evidence of the state might be doubtful.
Okay, no problem.
Court pleases me.
Right, is that you, Mr. Is that your turn now?
That's correct.
Thank you. Mr. Rapid?
My Lord, I thought the interpreter will interpret for the evidence of Mr. Mgomezu. Then I'll
No,
take
he's
it
going
over
to...
on Monday.
He's going to do it tomorrow, Monday.
On Monday.
Yeah.
Then, my Lord, I'm going to request that we adjourn until Monday.
Why? Because of the interpretation.
No, not because of interpretation, because I need to go through what Mr. Mgomezulu has gone through so that I don't repeat and burden the record with repetition of what he has said pertaining to accused 1 and 2.
You're not listening.
Yes.
You are not listening.
I wasn't listening to
What
his
Mr.
evidence.
Yeah, no.
No, not to his
the argument,
submissions. I have,
the
my Lord,
argument
but-
by Mr. Mgomezu.
I have listened to the
Oh, I see.
arguments,
Okay,
but
okay.
my Lord, we use language differently.
Oh, I
the
see.
way we understand it.
Okay. Mr. Baloi?
We are in the hands of the defense, my lord. We're not going to...
What's the time now?
It's 10 to 3.
Okay, so let's adjourn until Monday. Mr. Miyake, will you be ready on Monday?
My Lord, let me say,
What's that?
My Lord, I've been working on my head as a team together with Mr. Munyeki and Mr. Ngumalo and Ms. Misholo. That's why I wanted us to sit and butt heads so that we consolidate our arguments.
Well, I've got number 5's heads of argument.
So sorry, my Lord.
Accused number 5's heads of argument, I've got them.
But of Ms. Misholo, we've
Yeah.
worked together on all the arguments, my Lord. We were
So are you saying,
So we wanted to butt heads because already some of the stuff, the evidence and information has been placed on record by Mr. Mgomezu. So we need to see what to isolate and
Oh,
what
okay,
to
fine.
go to.
all right, okay, let's come back on Monday, 10 o'clock.
So we are
Jen. Sorry, before I adjourn, you gave me half a judgment. Where are the rest of the pages?
41, I think it's part of Mr. Mgomezu, but we'll make sure, my Lord, that the whole judgment is given to him.
Okay, I'm giving it to you because it's,
Unfortunately, it is highlighted. Now presented the full judgment.
sorry, you'll bring it the full judgment Monday.